A quick guide to Singapore's inward redomiciliation. How to convert a foreign company into a Singapore-registered company. On March 10, 2017, the amendment to the Companies Act of Singapore, Chapter 50 of the 2006 revised edition, was passed. One of the key amendments introduced in the Companies Amendment Act of 2017, CAA 2017, is the inward redomiciliation regime. Redomiciled company. How is it different from a branch or a subsidiary? Here are some of the notable differences. A branch office is the same legal entity as its parent company. It is merely regarded as the extension of the latter, the same overseas entity doing business in Singapore. A subsidiary has a separate legal entity from that of its parent company. The overseas parent company enjoys limited liability and is not deemed responsible for the acts and omissions of its subsidiary. As opposed to other entry options for foreign companies, redomiciliation converts a foreign company into a Singapore-registered company. There is only one entity throughout the process. The consequence only is that the rights and obligations of the foreign corporate entity are thereafter transferred to the Singapore-registered company. Perhaps the huge advantage of redomiciliating a foreign corporate entity over a branch or subsidiary is that it allows for the total continuity of business. Eligibility for redomiciliation, pre-registration compliances. The transfer of registration will be permitted only if the foreign corporate entity is authorized under its original jurisdiction to transfer registration. Size. If the applicant is a subsidiary, the size requirement is applied to a single entity, either subsidiary or parent only. But if the parent company applies, the size requirement will be done on a consolidated basis, subsidiary plus parent company. Solvency. An applicant for redomiciliation is required to submit a solvency statement to prove that it has sufficient assets in excess of its liabilities. Even if contingent, it is not unable to pay its debts or is able to pay debts as they fall due, even during the 12 months period after the application for redomiciliation. Post-registration compliances. The corporate entity should register pre-existing charges within 30 days from the date of registration. Governed by Singapore law. Once a foreign company completes the redomiciliation process, the registrar will issue a notice of transfer of registration. One and the same entity. The foreign corporation can continue its operations under the laws of Singapore as no winding up or liquidation is necessary in redomiciliation. Lower tax liability. The Income Tax Act was likewise amended to include provisions for the tax treatment of re-domiciled companies. If you want your foreign company to undergo redomiciliation in Singapore, contact our incorporation specialists today.